So the Supreme Court just ruled that there's no constitutional right to an abortion. So we're here to discuss how this can affect in vitro fertilization and assisted reproductive technology in general. Hi, I'm here with Sanford Benardo, and he is an attorney specializing in assisted reproductive technology. And we work together in the Northeast Assisted Fertility Group. We're an egg donation and surrogacy agency. So this Dobbs decision from the Supreme Court that came down recently has caused a bit of a panic among those involved in IVF, those with frozen embryos, because it can be kind of, extrapolated that the fertilized embryo somehow has personhood. At least there's a small section of the population that thinks that. There's nothing in this decision that references IVF at all, right? We both read it. Doesn't reference IVF at all. It just talks about really the historical aspects of right to abortion and how it's not guaranteed. It hasn't been historically guaranteed and all of that. It also assumes that the egg and the sperm come together in the woman's body. Well, it doesn't really mention women too much. It really mostly thinks of the fertilized egg as some kind of abstraction. And it just talks about viability kind of in the womb. It doesn't really mention embryos frozen outside the womb. It doesn't get into that at all. But people still...
That doesn't mean that the extension of the decision could go into these other areas. And that's what people are concerned about, right, Kat? Yeah.
So let's start this kind of a really direct way that we know it can affect what we do, and then a more indirect way with the frozen embryos, and also just IVF, creating, just fertilizing, bringing the egg and the sperm together in a petri dish. Mm-hmm. Okay. So directly, when we do a surrogacy, there is a clause in the contract that goes over abortion. Correct. Mentions abortion. Now, why would abortion even come up in a surrogacy contract? Why don't you explain that to everyone?
Okay. Well, Roe versus Wade has been the law since 1973 until a few weeks ago. So certainly it's been in place all during the time when we've been practicing in this field. So every surrogacy contract to date, the new ones will not indicate this, has said that Roe versus Wade is controlling law, and the woman has a right to decide whether or not she wants to terminate on her own. Nobody can force her to do so. What we have seen over the last few years is an erosion state by state when it comes to the application of Roe versus Wade, but it's always been sort of a backstop. Constitutional protection has always been there. Now that's been taken away, and the states are even freer to enact their own restrictive language. So what it means in a surrogacy case is that the carrier, should there be some genetic abnormality that is undetected by the previous testing, or some structural issue with the developing fetus, or some problem with her own health, which would indicate a termination might be a wise decision or something to contemplate. We now no longer have the constitutional protection for that, and we have to look at whether it's permitted in the state where she's living and where she's getting medical care, or if it isn't, at the time when it might be contemplated, thought to be done, whether she should be going to another state in order to have it done if she chooses. It's always if she chooses. Nobody can ever force her to do that. So while people are naturally concerned about this decision, and it's an awful way of looking at life, and it's terrible that we're going so backwards as a society, it doesn't have ramifications that are earth-shattering in the surrogacy field. It simply chips away even more at what we have been looking at over the last few years, which is a more difficult road to navigating a potential termination. But let's look at the fact that while termination, anytime there's a pregnancy, a rationale for a termination is foreseeable, it is just not what I would say reasonably foreseeable in a surrogate pregnancy that involves an embryo which has been thoroughly tested, which involves a woman who has no impediments or medical issues that might indicate that there's a larger percentage of opportunity for a termination. So we're looking at as low risk as possible going in. Doesn't mean it's not foreseeable. It's still remotely foreseeable, but just not reasonably foreseeable. So we still have to address the possibility in the contract, and even more importantly, with the discussions among the parties or between the parties, because what's written down is really not enforceable. It's what people are willing and wish to do. I have not seen in my practice as a lawyer or running this program a termination in over 15 years. The two that I can recall were over 15 years ago. And I believe that's because technology has gotten better all the time. It's getting better all the time. And there's more testing on embryos, and there's less of a chance of an abnormality going in. And medical care is getting better. So there are just fewer of these things happening in the surrogacy world. In addition, they're putting in one embryo almost uniformly now, unless there's really a justification for two. We never see three. And a selective reduction, which is another term of art, which is really an abortion, but it's just used in a sort of a softer way. It means taking an embryo out when there's more than one in order to give one a better chance of making it. Usually there's the philosophy. We don't see that too much anymore. In fact, I'm not even including that in many contracts because it is such an unforeseen possibility, especially when you're putting one embryo at a time in.
Right. So just to sum up, a surrogate pregnancy is never an unwanted pregnancy. There's a lot of time and effort and cost that goes into creating this pregnancy. Nobody would want to abort. There's no elective abortion. It's like, that's just off the table. The two things that would apply are some kind of abnormality with the fetus, which is certainly reduced now with all this pre-genetic testing that they do, so that they're able to sort out the genetically normal embryos and only transfer those. So that is greatly reduced. And because they're able to sort out the better quality embryos, they get to transfer only one at a time. Mm-hmm. So the chances of a dangerous multiple pregnancy where they transfer 4 embryos, hoping that one will take and 3 end up taking, a selective reduction is basically an abortion of 1 or 2 of those extra fetuses because there's a higher risk. And that's hardly ever done. It's done so little now, you don't even mention it in the contract, right? We
rarely mention it. But you're right. This is different than, hey, I was with this guy. It's not the right time for us to be together as a couple. I got pregnant. A termination decision would only be made in a surrogate pregnancy if there's a significant defect or threat of a defect, or if the surrogate mom's blood pressure is all over the place, or there are other things that are jeopardizing her own
and this
health.
Surrogate has been so thoroughly screened that she is absolutely 100% fit to carry this baby. That it's just, the whole different thing with IVF and assisted reproduction and this decision is people are desperate to have these children. And they're not trying to terminate unwanted pregnancies. They're coming from a totally different place. So
it rattles people. It definitely rattles people, and it should, because it's yet another roadblock in being able to have your own choices in life and freedom of autonomy over your body. But let's not let this have an overblown sense of fear. Let's not create that from a decision that really has a very small practical impact on what we're doing. It means,
at this point. And in my previous videos, I've said that IVF, assisted reproductive technology, is on the spectrum of reproductive rights. On one end is abortion, and on the other end is this. So, but sometimes these extremes come together when we have these kind of bans and legislations and things like that. So, all right, so that's for the surrogacy part.